Hello everyone, good morning. This is Belal Hamideh with Belal Hamideh Law. We are doing a live Q&A session today for anybody who has questions in regards to a variety of cases, whether that be workers' compensation, personal injury, or employment law. I have had already some questions come in that I have saved. I will begin to answer them now. If anybody has any questions for me, you can comment them in the Facebook Live comment section, and you can also send a message which I will receive, and I will do my best to answer everyone's questions. My intention is to help people in their claims that they are managing themselves. It is a David versus Goliath, these type of cases, most oftentimes going up against an insurance company who wants to pay you the least amount of money possible, and hopefully I can serve as a resource to you in gaining the most money out of your claims or cases. So let's go through some of these questions here, if I could just pull them up. So somebody asked, I have been an administrative professional for 23 years. 2 weeks ago, my fingers started to hurt when I type. Is that a work injury? So this is a workers' compensation question. In workers' compensation, there are two types of injuries. There are specific date of injuries, and there are continuous trauma dates of injuries. A specific date of injury is an injury that occurs on one day. For example, if you are a butcher and accidentally sliced your finger, that would be a specific date of injury. The date of injury would be the day that you sliced your finger. Another type of workers' comp injury that is less commonly known is a continuous trauma date of injury. Now, a continuous trauma date of injury is an injury that occurs over a period of time. It doesn't just happen on one specific day. It happens over a range of days. So the trauma that one can sustain typing each and every day for several weeks, months, or years, that trauma can manifest physical symptoms later, which we know as pain. However, the injury was occurring over a period of time. The manifestation of that injury, the pain, can occur after the injury. So for example, a secretary, if you worked somewhere for a couple of years, the date of injury would be that 2-year period. So if you are a secretary, if you have pain and you want to pursue a workers' compensation claim, what you're going to do is fill out a DWC Claim 1 form, and it's split into two halves. So the first half is for employee information to be input, and then the bottom half is for employer information to be inputted. And then there's a section there that references date of injury. What you're going to write there is continuous trauma, or you can abbreviate it as CT, and then the start of your employment, dash, and then the end of your employment. That is your date of injury. So yes, if you are a secretary or somebody who constantly is typing as a part of their customary job duties, and after a certain period of time you have pain, maybe because of carpal tunnel syndrome or tendonitis or any other type of inflammation due to the overuse of your hands, you may be able to recover money for any permanent injury that you may have sustained, and also you are entitled to medical treatment within the workers' compensation insurance network. We call that insurance network the medical provider network, or MPN. So what I would advise that you do after you fill out the DWC Claim 1 form and you submit it to your employer, they then submit that claim form to their insurance company, the workers' comp insurance company. The workers' comp insurance company assigns an insurance adjuster to the case, and then the insurance adjuster will send you to a doctor. Now, don't just go to the first doctor that they send you to. There's a lot of clinics that are notorious for being unfriendly to employees. So what you want to do to get the best medical attention in your workers' compensation case is you want to have the insurance adjuster send you the medical provider network list, and it'll show you a list within a few miles of your residence, and then you can look them up online to see their online ratings. What I would recommend that you look at is reviews regarding how much care they give to the client, how much they're paying attention to their complaints. Usually those are the more compassionate doctors, and the doctors that are able to provide better medical treatment to you for your injuries. Thank you for that question. I would submit a DWC-1 claim form and talk to your insurance adjuster about getting medical treatment, and then hopefully you can return to work soon. There's a few other questions that I have saved that I would like to talk about. My workers' compensation claim was rejected. Am I out of luck, and is there something I can do? I would say that the workers' comp insurance companies, they would like to find any reason to deny a work injury. They'll say that the work injury was unwitnessed, so they could not verify whether or not it occurred. They would say that due to your age, this is a degenerative disease, and if you're claiming a work injury to your back and you're of a certain age, they may say, you know what, this back pain is caused due to the natural progression in your age as opposed to you working for our company. So if a workers' compensation claim is denied, the recourse is under Labor Code 4060. What you do is you obtain a qualified medical evaluation. This is an independent doctor appointed by the state of California. They are not an insurance doctor. They review medical records relating to your accident. They interview you face to face. They conduct a physical examination, and then they issue a report. That report has to be written within 30 days of the evaluation. And the report is going to be very thorough. It's usually at least 20 to 25 pages. It has a review of medical records section. It has a section about what you say happened at work to cause your injury. It has a permanent impairment section, and it has a causation of injury section. So after the QME reviews all of your medical records and interviews you face to face, they make a determination as to what was the causation of your injury. Now, if they say that your causation of injury was due to work, then that would basically reverse the insurance company's denial of your workers' compensation claim. And then with that QME report, you now have the power to obtain medical treatment through the workers' compensation network and maybe get an eventual settlement for compensation. So just know that workers' comp insurance companies are looking for any reason to deny your claim. Insurance companies are not in the business of making friends or really helping injured people. They are in the business of making money, making a profit, and the more claims they can deny, the less money they can pay out for these claims, the more profit they will eventually make. But do not just let an insurance company deny your claim and make you feel like you do not have any ability to pursue a workers' compensation case. So that's another question that came in regarding workers' compensation denials. Here's another question that I have saved. I think I was fired for reasons I shouldn't have been fired. What should I do? Now, in California, we are what's called an at-will state. That means that the employer or the employee can terminate the employment relationship at will. That means that they can terminate the relationship whenever they will, whenever they want, and it doesn't have to be any justified reason. However, do not confuse that to mean that California is not very friendly to employees. There are a lot of laws under FEHA, the Federal Employment and Housing Authority, that does not allow employers to unlawfully discriminate against employees. So if you are part of a protected class of people and you are fired because you are part of a protected class of people, that is an illegal termination. So what is a protected class of people? You are protected if you are in a class based on your race, based on your gender, based on your age, and such. Also, in workers' comp, a big protected class of persons is persons that have a disability. And a disability is anything that affects your ability to do activities of daily living. So if you believe that you've been fired and the motivating reason of your firing was that you are part of a protected class of people, then that is an illegal termination. That overcomes the at-will employment because you cannot be fired illegally. So if you have a disability, your employer cannot just get rid of you, even though you can still do your job or you can do it with restrictions. Your employer has to give you reasonable accommodations. They have to give you a reasonable amount of time to get back to work. You see, in California, employers, the law is set up so that you do give your employee the best chance to return to work and you don't just fire them right away. So if you are part of a protected class of people and you believe that because you are part of a protected class of people, that was the reason of your firing, then you may have a case for wrongful termination or discrimination. Now, the statute of limitations for those type of cases is twofold. You have to make an administrative claim with the DFEH, the Department of Fair Employment and Housing. You have to make this claim within 1 year of the day of discrimination or the discriminatory act, and then within 1 year of filing that administrative claim, you then can file a civil lawsuit in Superior Court. So the statute of limitations is twofold, which makes it a bit more complicating. However, you do have the right to pursue a termination case if you feel that you've been discriminated because you are part of a protected class of people. Here's another question that I saved. I was just in an auto accident. I've gotten medical help, but I'm not sure what to do next. So car crashes can be dangerous. People often get hurt in car crashes. It makes sense. I mean, cars are made out of metal and they bend and break in a crash. We're made out of bones and blood and flesh. So naturally, if the car is damaged, it's likely that we have sustained a personal damage or a personal injury as well. So you do have the right to seek medical attention if you are injured due to a car crash. After you are done with your medical treatment, you then have to put together a settlement demand package and you send it to the insurance company of the other driver. Now, the other driver who hit you, who we are going to assume caused the crash and was at fault for the crash, they are going to have 2 insurance adjusters assigned to that one crash. The first insurance adjuster the other driver is going to have is a property damage adjuster. This property damage adjuster is going to contact you to set up an inspection and to determine how much it's going to cost to repair your car and then send you a check for the cost of the repair. You're not going to deal with that insurance adjuster at the time that you are seeking a settlement for your personal injuries. There is a second insurance adjuster, a personal injury insurance adjuster, and that's the person that you're going to send your settlement demand to. Now, in your settlement demand, you can claim multiple things. You can claim medical expense that you've sustained, either bills that are still owed or bills that you paid out of pocket. You can include loss of earnings that you've had from work. So if you missed any time from work as a result of your injuries, then you can claim that X amount of dollars as part of your settlement demand package. And then lastly and most importantly is the value that you put on the pain and suffering you've sustained because of this crash. Now, that's called a general damage because it's something that you can't just plug into a calculator as opposed to medical bills and loss of earnings, and it depends person by person. So if you had to miss events, or if you have to go through work with pain, or if you're just not the same person for a period of time, how much money do you think is reasonable to accept in order for you to have to endure that pain and suffering? And that's the value that you're going to put on your pain and suffering. So you're going to send the settlement demand package to the bodily injury insurance adjuster of the other driver. You're going to include the medical expense that you've sustained, either paid or outstanding. You're going to include the loss of earnings that you've had from losing time from work because of your injuries. And you're going to include what you think is a reasonable value for pain and suffering for having to endure the pain you've had as a result of the crash. The insurance adjuster will then negotiate with you, and then you may end up with a settlement. If you're not happy with their settlement offer, then your recourse is to file a case in Superior Court and then to deal with their attorney. So if you've been injured in an auto accident, that's the basic process on how to get reimbursed. And the last question that I have here, an insurance person contacted me after my accident. Do I talk to them? So it depends on what insurance company is contacting you after the crash. If the insurance company is your own insurance company, when you signed up with your insurance company, you agreed in a contract that you will cooperate with them in any investigation regarding a car crash. So you are contractually obligated to talk to your own insurance company after a crash. Now, the other person's insurance company is probably going to want to talk to you as well. You are not obligated to talk to them, and I always, I do not allow them to speak to my clients because we a lot of times file a lawsuit in regards to the car crash, and if I allow a statement the first time before litigation, they're going to get another statement at deposition, and you're just giving them multiple cracks at getting statements from your clients. However, if you're just seeking property damage and they just want to get your side of how the crash occurred, then I would probably advise you to just talk to them so that they can hopefully make a determination that you were not at fault for the crash and to agree to, pay for your property damage. So those are the questions that I've had saved. We intend to hopefully make this a weekly effort. I want to give back to people who are struggling, who are fighting on behalf of themselves for their injury claims, their workers' compensation claims, their employment dispute claims, our claims. And I encourage you to try to join us Saturdays at 11 a.m. as much as we are able to do so, and to leave your questions in the comments or to message me. You can also call my office to ask me the questions. It's free consultation. I give free advice all the time, and I do truly just want to help people with their claims. Whether you choose to do that on your own or with an attorney is totally up to you. I want to thank all who have joined for our first weekly Q&A session. God bless and have a great weekend, everybody. Take care.